What's going on, good people out there in YouTubian land? It is I, the Bad Wolf, the main man himself. What's going on? We in the house, so watch your mouth. Love and respect out there to the OGs who kept it down for us, the real men out there who have built the society, the system, along with the great women by their sides or at their forefront helping. um, all of you guys who came before us, thank you. Love, respect, and homage to all of you guys. Those known and unknown, seen and unseen, heard and unheard. Because just like right now, there's so many of us out here who are holding it down. We are fighting the corruption in the systems while working with the system. And to those people out there who are helping to help other people in a positive way, who aren't being negative and fighting other people, fighting each other. We've got a common enemy and enemies in line. So thank you to all those people out there who have light in their heart and are helping to do the right thing because it's the right thing to do. So if you guys are out there struggling, take time for yourself, breathe. It's okay to get off the horse. It's okay to be knocked down. These things are a part of life. Nobody runs a perfect race or perfect anything. It's not about being perfect. It's about you doing the best you can every day. It's about you putting your ego to the side and moving forward and helping those along the way who can't help themselves. If you can help yourself, I'm going to toss you a bone, but you have to pick yourself up. Because if I pick you up all the time, well, then you're going to get used to it. And then if and when I'm not there for you, you're going to resent me for it. So with that being said, let's get going, guys. Okay, so this is the next installment of the treatise on arrests that we've been covering. So if this is your first time here, you're just jumping in and catching this particular video. There are other ones before this one, and after this one should be linked to the one previous and the one next. If it's not, well, then you're gonna have to go back and look up A Treatise on Arrest and False Imprisonment by James C Lovett. I'm going to do a master version where I'm just going to have the lovely AI assistant read from beginning to end. And as always, guys, if you guys want the file itself for your own personal reading, you can go to blacksite32.com. It will be up there for free. And the download sections probably towards the bottom. They're not alphabetized, so it's kind of a hodgepodge. You go in there and just sort through the documents to see what you need. You do not need everything. As always, guys, make sure that you vet your information before using it. Try to stay away from scammers and people who want to degrade you and want to play little silly games and overcharge and all that trash. If it seems too good to be true, guys, it probably is. Also, beware of agents out there leading you astray. And crappy information. At the end, you just be careful, okay? Um, and remember the big thing here, guys, is that you already have you were born with your status or your standing, excuse me, your standing correct. It's just you've only been using your public side, so now you need to get in touch with your private side and utilize that just like the wealthy people do, okay? So other than that, once again, I am booked up pretty decently for the next couple of weeks. But you can still put yours in now and get your consult then, or you can wait a little while. It is what it is, guys. So we will be starting. Well, actually, we've already started seminars for select people in a VIP group style, where I'm going to be giving you guys all the information I know about how to deal with court scenarios, how to research and study certain things, health. We're going to have some people doing some trusts. We've got people who are going to teach you a little bit more about QSIPs, this, that, and the other guys. So the seminars are going to be very inclusive on all that information. So you guys will be made the masters, okay? Um, Once you guys go through some of these seminars, but there's already a lot of good research and information on my YouTube channel. So please use that as a library. And thank you for those people who are now watching more of the videos versus trying to email me, because if you didn't know this, if you haven't bought a consultation or the question package, I'm moderately, highly retiring from answering all the emails. I've done thousands of them. If you bought a product, I will still get to you. If you're part of the Wolf Pack, I will get to you. If you're just sending out a question, don't be mad if I don't get to it, because answering between 50 to 150 or so odd emails every day, 7 days a week, because if I miss 2 or 3 days, it's like 300. You know what I mean? And it's like, oh my God. So I'm just retiring from that a little bit. Doesn't mean I'm retiring. I don't even know if you can really retire from this. Um, but yeah, so thank you for those people who helped build the channel to where it is. With the higher demand for things, I just don't have the time. Plus, it takes away from my family, my loved ones, and whatever else. And I'm not getting, paid for all those free emails. I enjoyed it, but now that my life is moving in a more positive direction where I need to spend more time with family, I will still be making the videos, but I just don't have the time. So sorry in advance, but thank you for those who've helped me, and hopefully all the people that have helped appreciate it. So you can still send an email, but it may or may not be answered. Don't take it personal. Just keeping it real. Just want to let you guys know how things are moving. If time or whatever else opens up, in all honesty, I hope it doesn't. Then I will get back to answering a lot more. But for right now, if you really want things done, that's how we're moving. All right. So other than that, as always, guys, if you see anybody using any of my information or calling me the S word or trying to do some silly hokey videos, making themselves look cool or whatever else, talking trash, report them for bullying, slandering, defamation of character, which are suable offenses. And other than that, make sure you guys take care of yourselves. So I haven't said this in a while. Don't forget to hit that bell, like, subscribe. So with that being said, let's get into it. Come on, Wolf, let's go. All right, so let me chop it up here. Hope everybody's doing good. I wish you guys a happy holiday season. I really do not like the winter. It's pretty to look at, but then when you have to get out there and shovel and snow blow and salt and your car gets stuck, and yeah. Anyway, all right, so share screen. All right, so the next installment is here. Let us commence.
Breach of the peace and felony arrests.
All right, so this section is going to be breach of the
Arrests.
peace and felony arrests.
What is a breach of the peace? A breach of the peace may be generally defined as a violation of the public order which amounts to a disturbance of the public tranquility, or by inching others to do so. It is clear that not every misdemeanor is a breach of the peace. To constitute a breach of the peace, there must be some violence or harm existing or threatened to occur to person, property, health, or morals. Affrays, assaults, riotous conduct, or destruction of property make up the largest part of what can be called a breach of the peace. Thus, in the majority of cases of a breach of peace, some actual violence is present. In some states, there has been attempts to expand the meaning of breach of peace to include all indictable misdemeanors, but this, it must be confessed, is doing serious violence to a simple expression, easily and well understood. 1. Some of the types of breaches of the peace are described as follows. Raj breach of peace includes acts of public turbulence, acts of violence or tending to produce violence, or tending to incite violence, disturbance of the public tranquility by yelling, hollering, or uttering loud and vociferous language, making disturbing noises on a public street by one in a state of intoxication, wanton discharge of firearms in a public place, engaging in an affray or in an assault, uttering abusive, profane, indecent, or otherwise provocative language. Point 2. In discussing what constitutes a breach of the peace, the Supreme Court of North Carolina held, a breach of the peace is a public offense done by violence or one causing or like ly to cause an immediate disturbance of public order. 3. Breaches of the peace are acts which are malum in esse, being wrongful or evil by their nature. Thus acts which are malum prohibita, or those acts made wrong merely by a statute, cannot be classed as a breach of the peace. Those acts which constitute a breach of peace have been settled throughout the course of the common law. The legislature cannot declare any act they choose to be a breach of peace. The nature of the act determines if it fits the common law definition of a breach of the peace. The acts that are only malum prohibita include liquor prohibition laws, traffic laws, labor laws, health laws, food laws, building codes and zoning ordinances, safety acts, game laws, and very many other police regulations. Without a statute, most of the acts constituting these offenses would be innocent acts. 4. A parade on the street is not of itself a breach of the peace, though it could constitute. Walter Anderson, A Treatise 011, The Law of Sheriffs, C. Oralin, and C. Lobiu. Volume 1, Section 131. Pages 126 to 27, 1941. 212 American Jurisprudence, 2d, Breach of Peace, Section 8. Pages 669-70, 3 Stott v. Mobk, 240 NC 476, 83s.e.2d 100, 104, 1954, authorities cited. 4 Allen Y. Stale, 183 Wisconsin 323, 197 NW 808, 811, 1924. 1. S. The carrying of arms in a quiet, peaceable, and orderly manner, concealed on or about the person, is not a breach of the peace, nor does such an act of itself tend to a breach of the peace. 6. A mere trespass is not a breach of the peace and does not impose criminal liability upon the wrongdoer. 7. Driving an automobile while intoxicated constitutes a breach of peace. 8. Indecent exposure is where one is walking in public, naked or nearly naked or in indecent dresses, disruptive of the morals of society and constitutes a breach of the peace. Blasphemy of Christ or Christianity in public is a breach of the peace. A mere violation of public decorum or a penal law does not constitute a breach of peace. 9. Conduct merely amounting to a nuisance is not per se a breach of peace. 10. The sale of 15 dynamite caps to a 5-year-old boy did not constitute a breach of peace. 2a. Theft is not in its nature a breach of the peace. 12. A charge of disorderly conduct is a broader term than a breach of the peace, because a person who commits a breach of the peace is necessarily guilty of disorderly conduct. However, all acts of disorderly conduct are not necessarily a breach of the peace. Littering or yelling are such cases. 27. Breach of the peace is a common law offense, but it is not itself a specific offense. Thus, in a charge or indictment, the specific offense must be specified. Arrests for breach of the peace. In the struggle for government to claim and exercise greater powers of arrests, it has unlawfully attempted to apply the common law rule for a breach of peace arrest to all misdemeanors. The general rule of law under the common law for the arrest of misdemeanor offenses amounting to a breach of the peace is stated as follows. In cases of misdemeanor, a peace officer, like a private person, has at common law no power of arresting without a warrant except when a breach of the peace has been committed in his presence or there is reasonable ground for supposing that a breach of peace is about to be committed or renewed in his presence. An arrest can only be made to suppress and prevent the breach of peace, and if the act ceases, there is no longer justification for the arrest without warrant. A constable cannot arrest, but when he sees an actual breach of peace, and if the affray be over, he cannot arrest, and where a breach of the peace had been committed and was over, the constable must proceed in. 5 in Shields Y. Stat. 181 Wisconsin 448, 204 NW 486, 40 ALR 945. 6 Wharton's Criminal Law in Proudhon, 12th ed., Volume 2, Breach of the Peace, Section 803, page 660, 1951, 12 American Jurisprudence, 2d, Breach of Peace, Section 8, pages 669-10, Judy v. Lashley, 50 W.VA is 628, 41 C 191, 200, 1902, Robertson v. State, 43 Flaw 156, 29 So. 535, 538, 1901. 7 Wharton, Op. Cit., Section 804. 8 Stott Y. Rue, 72 NM 212, 382 P.2d 697, 700, 1963, State v. Jennings, 1120 Hio App. 455. 176 N.E.2d 304, 307. 9. 12 Radlaw. / 14. 28. The same way as any other person, namely, by obtaining a warrant from a magistrate, s. The rule for arrest without warrant involving misdemeanors was stated in an article in the Michigan Law Review as follows. Neither 0, a peace officer, nor c, a private citizen, may arrest d, a person, for m, a misdemeanor, which is not a BP, a breach of the peace. In regards to this rule it was stated.
So, switch up. Shazam. All right, so what I want you guys to understand here, and there's more to the court side of things and whatever else, but I'm building a framework here for you guys to understand that though a police officer, understand this, a police officer is not true law. Okay, now before you guys get upset, including my friends out there who are officers, there's a difference between lawful and legal. The police officer, most of them are actually in for-profit corporations. So they're not lawful because they're not doing the sheriff's work who's operating under the Constitution. They are constitutionally in charge. Okay? So though they can do what they're doing, it's only for those people really who are underneath their jurisdiction, which are 14th Amendment U.S. citizens, which depending on how and what you are operating as in that moment or in the event, you're probably public because you got their driver's license, you got your all capitalized legal name on everything. You're operating in the public. And then when asked, you're going to say, I'm a 14th Amendment or I'm a U.S. citizen. So then, yeah, you're subject to that. You're a federalized citizen. Different than when you're operating privately with your own privately made IDs, your private stuff, your things are in trusts, et cetera, et cetera. So here are some key takeaways. A private citizen, a U.S. citizen, and a police officer can stop anybody. Any of those people can stop any of them. I can stop a police officer if he's doing something criminal, whether he knows it or not. Now, is that a good idea to just say, hey, and do something? Probably not, because he's going to try to justify, and let's be honest here, this is an honest channel. If he's doing something illegal, it's either because he doesn't know or he doesn't care. And he's going to rationalize that by calling somebody like me or whoever else, oh, you're a sovereign citizen. He thinks he's above the law, to try to get away with the BS that the bad ones do out there, which then makes the good ones out there look like trash, which is why I've always said, how many bad cops do you have if the good cops don't stand up to them? Okay, said it since day one, not backing down on that. Prove me wrong. So the whole thing here is that anybody can stop anybody if they're doing something criminal. You've also heard it as citizen's arrest. Okay, that means nobody has the right to breach public safety and endanger the public, period. So a lot of these cops are now starting to be retrained because they don't understand constitutional law. See, the courts and the people who operate the courts on the upper levels don't want the cops to know. They want the cops to take the beating, and then the police want to be mad at people operating their constitutional rights, but then when they get sued and lose their house, their car, their children's funds, their wives are brought into it, etc., then they want to be mad at people like me. No, you need to be mad at the people above you who didn't teach you constitutional law, because that is lawful. That is the highest law of the land, operating under the Constitution, for which you are an American. And if you're not operating by this, then you are a traitor, and it's treasonous. Period. But I can't be mad at you guys, not the good ones, because you don't know. But the good ones who do know and who operate correctly, my hat goes off to you as a fellow patriot. It's the other ones out there who are either ignorant willfully or immoral and operating as bad cops. All right. So now that you know that anybody can stop anybody, okay, you have to articulate that, hey, what you're doing is a federal offense. It's a crime. It's criminal. It's treasonous. All right. But I'm not telling you to go out there and do anything. I'm just saying you now know that you have the capability in the right circumstance. That doesn't mean you can just stand up to somebody with a gun, cop, or whatever else. I don't recommend that at all, especially if you don't have one. And I'm not saying get into trouble by doing anything. I'm just saying that in certain moments, you now know that you have those rights and liberties. Everybody. It's not just the cops. Cops are the ones who have to do it, and most of them do. But some of them are bad and trash, and they know who they are. Most good cops know who the bad ones are, but they want to protect the blue line. Well, if you're protecting the blue line, you're not doing your job, because your job is to protect the U.S. citizen, the national, the American, the patriot. That's your real job from all threats, foreign and domestic. So let's get back to it. But what they're telling you here is that there are protocols in place. It's just that the average person doesn't know them. So let's get back to it. All right.
Stated. F. Neither an officer nor a citizen may arrest for a misdemeanor which does not amount to a breach of the peace, even though it occurs in his presence. As for example, talking loudly in the street in the presence of the officer, who ordered the parties to be quiet. An arrest without a warrant was not justified, nor where D in the presence of 0, was turning toward the wall for a particular purpose of relief in the street, or where he was disturbing a public meeting, or obstructing the free passage across a bridge, or refusing to move on a sidewalk at the request of an officer, or fraudulently substituting a smaller for a larger check, or fraudulently evading payment of a railroad fare, or maintaining a billboard on a sidewalk, or insulting the head of the house in the presence of his family, or assembling to witness a Sunday ball game or a movie show. 6. It is a common rule that an officer cannot arrest for a breach of peace after it has ended. When a breach of the peace ceases, the reason for the arrest ceases, that being to stop or.
Now, hold on. Now, that's something I didn't know. I did not know that after it has been done and they show up, that they cannot arrest you. That is a new one for me. I am learning so many new little key pieces. Matter of fact, we've also had some more victories. I know I don't really talk about them, and I don't brag about them. I don't need to. The proof is in the pudding, the work is in the work. So I've been emailed by some people who've sent me their court cases. Some have directly used my information, some have directly consulted with me, and we've been winning court cases left and right. Now, once again, I personally have told you guys I don't do court cases. I don't like to get involved but people have been kind of like, asking little questions on their stuff through their consults. Once again, I don't mind helping you out to be private and certain and the passport stuff. But the court cases, I do have a consult fee now, which is appropriate for helping with court cases. But understand, I can only put you in the right direction. I can do more in most regards than your lawyer, but you're still going to have to do the work, okay? Put in the motions and the information and fight and whatever else, and be prepared just like your lawyer to either win or lose. But there's a different fee for that type of consultation. Okay, so we're no longer going to be sneaking in these court cases when you're talking to me. All right. I haven't said no to those before, but now I'm saying that, look, I've put out enough information where you guys can do a lot of the work yourself. And if you want me, you have to, there's a fee. And I'm still, like I said, one of the cheapest out there for the best. All right. A lot of other people are talking their talk, all right, but we're showing the proof. Okay. And by that, let me understand. I'm not going to show you guys their court cases, but we have the wins. Okay. You guys can join my Telegram group, because that's where a lot of people are commenting on. They're like, thanks, Wolf, this, I use this, thanks for the consultation, and some of them, if they want to put up their information, that's fine. But join the Telegram group. You can see that we've got the victories. They're posting them up there. It's their information. I never will post anybody's private information, names, court cases, or whatever else. It's not mine to share. But I will say that we have the victories. All right. And it really shouldn't be that wowing, because when you know what's going on and you know how to fight for your rights and liberties with the Constitution and case law or Supreme Court opinions, it's a slam dunk. Here in America, in other countries, it might be different. We have a unique scenario here. All right. Other countries, I don't know what to tell you. That's a whole other problem I've been really thought about trying to fix. I'm trying to deal with what's here first. But yeah, so we have been very successful, very, very. I mean, we've easily 95% success, because these are your rights and freedoms. And when you know how to use them, you will be successful. But don't come to me after you've done something dumb and then try to lie about it, because I do require you to tell me the truth. And there are some cases and things that I will not take. All right. Because if it involves hurting kids, or, moving some drugs and things of that nature, or you hurt somebody where there's a living person, I don't do those, because those are crimes. I don't do anything criminal like that. All right. So that being said, let's get back to the information.
Or prevent the breach of public order. Mr. Bishop, in his treatise on criminal procedure, speaking on the subject of arrest for breaches of the peace, says, after the tumult is over, with no prospect of its renewal, it is too late to interfere without judicial process. And other past misdemeanors are within the same rule, namely, that a private person, or even an officer, cannot without a warrant arrest one for a misdemeanor committed on an occasion already past. 1 Bish. CRIM. Proct. Sections 166, 167.11. The principle behind the common law rule of arrests was that in order to prevent harm, violence, or disturbance to the public peace, it is necessary that those perpetrating such acts be promptly stopped by arrest. Where, however, the offense is an accomplished fact, its prevention is no longer possible. Also, if public order has been fully restored before the officer appears, the power to arrest without warrant for a misdemeanor breach of the peace no longer exists, for the end by which such authority to arrest is allowed to maintain the public peace is no longer attainable. 18. The occasions which would justify arrest without process for vagrancy would indeed be very rare, inasmuch it involves no immediate danger to public or private security. 19. Under American common law, no one can be required to give an account of themselves, or to show they have a visible means of support, or that they have employment as part of the right to life. All have a right to choose how to live and how to. I.S. Stahl v. Lewis, 50 Ohio Republic, support themselves, and no government act can interfere with this right. The majority of misdemeanor offenses would not fall in the class of a breach of the peace, which allow the immediate intervention of authority by arrest, as they are not an offense of a grave nature, or because they do not actually disturb the public peace. An arrest for breach of the peace in the officer's presence must be made promptly, either at the offense or as soon as the circumstances permit. If the officer does not act immediately after the offense has been committed, he can thereafter make arrests only by procuring a warrant. 20. When an officer, after having seen a breach of the peace committed, departs on other business or for other purposes, and afterwards returns, he cannot, without warrant, make an arrest for the offense, but where the officer find it necessary to procure assistance, a reasonable time may be employed in the pursuit. In such a case, the officer must at once set about the arrest and follow up the effort until the arrest is effected. An unreasonable delay will make the arrest invalid. In order to justify a delay, there should be a continued attempt on the part of the officer to make the arrest. It has been erroneously stated that officers are authorized to break in a house or building to prevent the commission of any crime without a warrant. This is an invalid. 29. Exaggeration of the true law on the matter, which is revealed as follows. The authority of a constable to break open doors and a arrest without a warrant is confined to cases where treason or felony has been committed, or if there is an affray or a breach of the peace in his presence. 2 Ha-Lu P. 88-96, 1 Hawkins, C. 63, Section 16, 1 Russell on Crimes, 629, I.Chitties Criminal Law, 14, 15, Bacco N. ABR Constab Lu, C. 21. The cases in which a breach of the peace occurs in the presence of an officer when done in a building would be very rare. The cases of felony and treason in such a case would most often occur where the felon was pursued into a building by the officer. Public drunkenness unaccompanied by language or conduct which creates a breach of the peace will not justify arrest without a warrant. 22. Impudent, abusive or offensive language addressed to a peace officer does not tend to breach the peace, even though it may provoke the officer to anger. 23. And it has been held that the mere refusal to give one's name and address does not justify the incarceration of a citizen. 24.
Exactly. Booyah.
Threatened breach of the peace. An officer cannot arrest because he thinks or has suspicions that a breach of peace might be committed. The cause for arresting upon such cases must be when a breach of the peace is threatened or its occurrence is imminent. 25. In determining when officers. 24 a.m.
Okay, so what this is right here, what they're saying is the officer needs an RAS. All right. For those people who don't speak cop language, RAS is a reasonable, articulable suspicion. That means that they have to have and believe that there's a crime that has been either committed or that it is in current occurrence being committed, or that if they don't act now, which technically is pre-crime, that it will be committed. Okay, can't arrest somebody on pre-crime. But what they do is it's a sliver of the law where if they see you chasing somebody with a gun and you're like, I'm going to shoot you, and then they run into the house, they have the ability to then chase you because they're like, that looks like it's about to go down. But if not, then they don't have their RAS. Some cops will overstep that, or maybe some of them haven't been properly trained, which can be used against them in court too. And they will do these things. Now, I'm not going to say that some of those things, that even if the cop was wrong, that it didn't benefit in the long run of things. But if you were a defense attorney, you could use that to help get that person free, even though they've committed something, wrong or atrocious or whatever else. So this does go both ways. It's not a clean swing of the broadsword. It's a double-edged sword because in that moment, he's putting people's lives in jeopardy, and yet they will tell you that they have no, how should I say this? A police officer has no responsibility to protect you. This is the fact. We all think they do, not since they stopped being peace officers. They are legal enforcement agents. Okay. It's one of the reasons why you don't see the word America on there. Most of them are all private, really, and for profit for 14th Amendment U.S. citizens only. So they can pick and choose what they want to do, who they want to protect. And if they think that their life is going to be in more jeopardy than pursuing a criminal or helping you, you don't have to do it. It's not like the old days where they had to do it and they were held to it. Nope. All right, so let's get back to it. The more you know.
Am jure 23 24 square 2 30 may interfere by an arrest to prevent a threatened breach of the peace, the Supreme Court of Michigan stated. We are of opinion that a threat or other indication of a breach of the peace will not justify an officer in making an arrest, unless the facts are such as would warrant the officer in believing an arrest is necessary to prevent an immediate execution thereof, as where a threat is made coupled with some overt act in attempted execution thereof. The object of permitting an arrest under such circumstances is to prevent a breach of the peace, where the facts show danger of its being immediately commit. Point 26. Thus the interposition of the officer in a threatened breach of the peace is not for the purpose of an arrest, but to prevent a disturbance or breach of the peace under a present menace of violence.
Now, the thing here is that a lot of police officers have quotas, and of course, it makes them look good to have more arrests and tickets, even though they say they're not supposed to and they don't do quotas anymore. Yeah, you bet your bottom dollar that they still do because it looks good. And as the officers go out there and do their thing and makes the cop look good so he can get a watch after 30 years, then what happens is it makes the station look good, and then ultimately makes the chief of police look good, or the commanding officer look good. And then they get their nicer watches and vacations and whatever else. It's a business. Okay. They want to also then be able to say, hey, look, while we're taking your money and your tax dollars and this and that, and these bonuses, and the other programs that go on that most of you guys don't know about, where they're paid a whole lot of money for nothing and they get tactical gear, military grade, and whatever else. Seems a little crazy to me, but anyway, that they can then throw these numbers to the higher ups to make sure that they can continue to get the good funding. And not all that money is accounted for. Oh yeah, not all that money is accounted for. Some of it's being misappropriated, but we'll leave that alone for now. So then they can thus say to the city and to the governor and mayor and alderman, hey, look, these are our numbers. We're doing way better than last year. At the end of the day, if you really think about it, if crime is up, one could say then you're not doing your job. If crime is down, they can say, well, you're doing your job, so that's good. This is working. But really, at the end of the day, the powers that be want the crime up so they can keep asking for more money. Crime goes down too far, then people go, well, hey, we don't need to fund you so much. Most people are being good. And remember, they're for profit. They're making a profit. They're profiting off of the crime. We sit back and go, okay, well, I mean, I guess so. You know, if that's what they got to do, it keeps them safe. And yeah, there's something to be said about that. but there's a lot of corruption. There's a lot of mismanagement of funds. And at the end of the day, they are doing a better job than not being there. So does the ends justify the means? Well, it's not a perfect system. And right now it's all we got. And due to people not being able to govern themselves accordingly, operate as non-belligerents, non-combatants, chase the almighty dollar, it's better to have something than nothing. Let's keep going.
The courts are almost unanimous in their holdings that a threatened breach of the peace will not justify an arrest without warrant, unless the facts are such as would warrant the officer in believing an arrest necessary to prevent an immediate execution thereof, as where the threat is made coupled with some covert act in attempted execution thereof. In such cases, THC officer need not wait until the offense is actually committed. Point 27. The guideline then for making arrests on what is to be lead a threatened breach of the peace is when the conditions are such that the threatened breach of peace is imminent, or that it is obvious, 0 the average person that it is going to occur. As held by the Supreme Court of North Carolina. 25 PDA 2. Slot, 227 MD 28, 175A.2 D11, 16, 1961. 26 Quinn v. F1 DSD, 40 Michigan 576, 578-79, 1879. Lee think a breach of the peace is threatened if the offending person's conduct under the surrounding facts and circumstances is such as reasonably justifies a belief that the perpetration of an offense amounting to a breach of the peace is imminent. Point 28. Since the nature of most breaches of the peace are such that cause violence to person or property, the acts which constitute them are apparent, so that one can readily see or hear them occurring. It is said a breach of peace is committed in one's presence when, by the use of his senses, he knows of its commission by the person about to be arrested. Thus an arrest for a breach of peace may be made when one's senses afford him knowledge that it is being committed, whether through sight, hearing, or other senses. 29 An arrest for a breach of the peace cannot be made on suspicion or mere belief. An arrest for a breach of the peace cannot be justified merely upon belief or suspicion existing in the mind of the officer, but, where the actions of the person and the surrounding circumstances are such as to indicate a threatened breach of the peace, the arrest may be lawfully made. Point 30. It is thus said that an officer cannot arrest for a misdemeanor or a breach of the peace based solely upon information from another, or suspicion without a warrant. In no case could advice or information given after the arrest was made justify the arrest. Likewise, an arrest cannot be made for one purpose and justified for another. 27 Hallerbecken v. Hollingsworth, 250 S. W. 261, 265, Texas Civ. App. 1923. 28 State v. Mobley, 240 NC 476, 83 S.E.2 D 100, 104, 1954, authorities cited. 29 Restatement, Torts, Sector 119, Walker I. Unit Slates, 7 Federal 2D 309,311, 9 THCIR 1925, Wharton S. Criminal Procedure, 1 foot 1.1 inches, Arc 5T, Section 65, 12th ed., page 173. 30 Hughes v. State, 145 Tennessee 544, 238 SW 588, 596, 1922. Conditions of felony arrests. It was regarded under the common law to be a right and a duty for a citizen to arrest one he sees committing a felony without a warrant. As stated by Justice Platt, all persons whatever, who are present when a felony is committed, or a dangerous wound is given, are bound to apprehend the offenders. 3 Hawkins, PC 157, AMSL, S. 1. To arrest a person for a felony not witnessed by the officer, he must be able to conclude from the facts then existing that a certain person did commit the felony, so that any prudent person would be led to believe likewise. An arrest for felony based upon suspicion, belief or rumor can never be justified for any cause whatsoever, not even by a warrant can such an arrest be lawful. Where there is a felony and it is passed, the officer is justified in arresting though no offense has been committed, yet he must have had reasonable cause to suspect the one apprehended. 32. To allow arrests for suspicions, even in the case of felony, would make everyone susceptible to arrest who the officer might choose to believe is a likely or possible perpetrator of a crime. It would in effect amount to a general warrant in the hands of any officer, a concept which was found to be so abhorrent to the founding fathers of the American Revolution. All arrests for felonies not seen or witnessed by the officer or citizen making the 31. Arrest have the burden to justify the arrest. In a felony arrest by a private citizen, he must justify the arrest by showing that the felony had actually been commined, and that he had reasonable grounds for believing the person arrested to be guilty. 33. An officer is required only to show the probable cause existing for making the arrest, and need not show that a felony actually occurred, though such proof could serve as a justification. 34. In all other arrests, probable cause is not a factor in justifying an arrest without warrant. It is well settled at common law that an officer or private person, without warrant, may lawfully seize and detain another in cases where a felony was about to occur. If two persons be fighting, and there be reason to fear that one of them will be killed by the other, it will be lawful to part and imprison them till their anger shall be cooled. Bacon, ABR, de trespass, d. 2 roll. ABR, 559. Double quotes, single quote, and private persons may justify breaking and entering the plaintiff's house, and imprisoning his person, to prevent him from murdering his wife. 35. The law on felony arrest allowed all peaceable persons to travel freely anywhere without having to worry about an arrest or warrant for a felony. This is because all persons know what constitutes a felony, that being intrinsically evil acts such as murder, kidnapping, rape, arson, mayhem, armed robbery, and other such atrocious crimes. No one commits a felony accidentally or without foreknowledge of the act. Thus a felon's arrest comes as no surprise to him. 31. Phillips against Trull, 11 Johnson's Republic 486, 487, New York 1814. See also, 6 A CJS Arrest, Section 13. 32. The State vs. Underwood, 75.
All right. That is it. So I want to thank everybody here for watching the video, and we are going to continue. So there should be a link popping up to the next video in this series, and that one will be defense to unlawful arrests. All right, so stay tuned, and we'll be back in 2 and 2.